Your spouse just told you, get out of the house. You got to be out by this evening. Worse yet, you get home from work and the locks have been changed. Do they even have the right to do that to you in Michigan? Before you pack your bags, let's talk about your legal rights and the reality of, can a spouse actually kick you out of your own house? I'm Jim Krayeveld, founding attorney at Krayeveld Family Law, and been doing this for about 30 some years. It is a really common problem and a common question that we get a lot of initial phone calls. Can they kick me out? I want to break down the rules step by step so that you know exactly what a spouse legally can do and what they legally can't force you to do. Basic Michigan property law. Michigan's an equitable distribution state. So until there's a divorce judgment in place and a judge has made a final ruling or the parties have reached a final agreement, both spouses generally have equal rights to the marital home. Sometimes a spouse will say, but it's titled in my name only. Nah, you're married together, you live together there, it's your house, and you have every right to be there as well. It doesn't matter if only one spouse's name is on the deed or one spouse's name is on the mortgage. If you're both living there, it's marital property. So, typically, neither spouse can just simply order the other one out, even though that happens. And then there are ramifications when one party actually does leave, somewhat voluntarily. When, however, can a spouse be actually forced out? And that requires a court order, usually through divorce or separation proceedings where there's an order for exclusive use or there's a personal protection order that requires one of the spouses to leave. Judges can issue temporary orders, granting one spouse exclusive use, also called exclusive possession of the marital home. In cases where there are safety concerns or domestic violence, that will fast track orders to get a PPO in place, personal protection order. And thirdly, sometimes police become involved and they ask one of the spouses to move out. So, the most straightforward one, if there's a personal protection order in place and you get served with that, then one spouse can legally remove the other spouse from the home, typically for safety reasons. Courts granting exclusive use orders often do so for cases of stability of the children and if there are other family dynamics in place. And again, those both can be objected to, but once they're there and they're in place and they're signed by a judge, you have to honor the court order. PPOs last for 6 to 12 months and can be renewed. Your temporary orders for exclusive use typically only last as long as the divorce case lasts. 6 to 12 months until there's an actual judgment. Sometimes the exclusive use orders are obtained ex parte. It means that it's an immediate filing with an immediate order, and you don't even have a chance to participate and object to it. Now you can after the fact. There's always an opportunity for a hearing. Typically you have to file objections within a limited number of days, and then you ask for a court to say, no, the motion was based on lies, that's not the truth, here's reality, please set that aside. One thing I've sort of half intimated at, there are risks of leaving voluntarily. Someone says, you need to leave. Okay, I'll leave. That can impact your custody position. The one spouse is going to say, they moved out, they left the kids, they didn't care. They left and then they didn't have contact with the kids while you were waiting for something to get filed or waiting for a court hearing. Those are all things that will set aside the party that leaves voluntarily. Again, presuming no court order in place. It can also complicate your property negotiations. The concept that there's perceived abandonment or desertion of your property. Didn't care about keeping the house, didn't care about his or her personal property, just left. So, unless there's a court order that gets served on you that requires you to leave immediately, please consult with an attorney before you leave the marital home. Caveat is, we're aware that there are contentious cases. Sometimes when the police show up because there are domestic disputes. You may avoid a criminal charge, and sometimes it's wiser to move out. But if the police require you to move out, or you think it's better to stop the contentious cases where you think something is going to spiral further out of control, get a hold of an attorney. Take legal action immediately. Figure out what your rights are, whether you should or shouldn't, and get something in place. Yes, as I've discussed, there are practical different examples. The one spouse saying, I paid for the entire house. I owned it before the marriage. My name is on the deed. They, without a court order, can't enforce to kick you out. Extreme opposite case of that is if there's a PPO in place, or if there is a custody or divorce case that has you served with a court order that gives the other party exclusive use, you're required to comply with those court orders. Don't violate the court order. The third option, which is a little more gray, is of course when there's either a contentious case or arguments or allegations of violence and the police show up and say, you really ought to move out. Maybe you want to do so for that one night until you can figure out what your rights are. But those are your three different areas. The thing I'm trying to point out is if there isn't a court order, remember that moving out has long-term considerations. Courts are going to look at property division and home ownership during the final divorce judgment. Now, temporary orders don't necessarily determine the final outcome, but they can influence them. Sometimes if it's a 50-50 and both parties can afford to buy out the other, they may be able to keep the marital home, assuming they can buy the other out in the settlement or at the end of the day and not be forced to sell the house. Secondly, think of the financial consequences of leaving the home. If you continue to pay for everything, the other party is going to say, look, she has the ability to pay spousal support, child support, and continue these payments in some form or another. You need to take all of that into account when you decide what you're going to do. And anything that becomes longer term will affect you more substantially than an overnight or a temporary change of location. So, in sum, a spouse can't legally kick you out of your own house in Michigan without a court order. If they try to do so or ask you to do so, consult with an attorney immediately and know your rights. You can protect your rights. You can protect your family. Until next time.